The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everybody. Thanks for joining us for today's webinar on getting help with Medi-Cal in-home services. I'm Pip Marks. I'm the Project Director for Family Voices of California, and I will be hosting today's webinar. Let me just move that along. Sorry, just having trouble moving my screen along. So before I introduce our speaker, Will Liner, I'd like to tell you just a little bit about Family Voices. We are a statewide coalition of locally based parent-run centres and we work to ensure that children and youth with special healthcare needs receive quality healthcare. And as the state affiliate of National Family Voices, we are California's federally funded family-to-family health information centre, and we provide statewide support and resources for families and children with special needs. Our webinars serve as statewide trainings on various child health related topics and are geared towards very diverse families, professionals, parent-to-parent resource centres and advocates. So, and if you have any technical difficulties with this webinar, you can just call the number that you see on your screen there. And due to feedback issues, we do keep everybody muted from our end. Throughout the webinar, please feel free to type in any questions that you have for Will on the right-hand side of your menu. We'll save time for your questions at the end of Will's presentation. Today's webinar is being recorded and will be archived, will be posted on our website by tomorrow. And after this presentation, you're going to be emailed a very short evaluation survey, and we would really appreciate you taking the time to give us your feedback. So now it is my pleasure to introduce today's speaker, Will Liner. Will is a managing attorney with Disability Rights California, DRC. DRC is California's protection and advocacy system. He leads the work of DRC's Intellectual and Developmental Disabilities Practice Group. Through a combination of legal representation, public policy, and systems change advocacy, DRC's Intellectual and Developmental Disabilities Practice Group specializes in advancing Olmstead and Lanterman Act rights by improving access to community-based services and supports, fighting disability discrimination by public entities, and challenging practices that curtail the rights of people with intellectual and developmental disabilities to direct and control their own lives. A major focus of Will's work has also been ensuring that individuals with intellectual and developmental disabilities have the opportunity to move from institutional settings to homes in the community where they can participate in social and economic life. He was a counsel on Capital People First versus Department of Developmental Services, which was a class action lawsuit that challenged the unnecessary institutionalization of thousands of regional centre consumers in public and private institutions. Will is also lead counsel in the IN versus Jennifer Kent, which is a class action lawsuit challenging the state's failure to arrange for the Medi-Cal in-home nursing services that thousands of children and youth across the state need to live safely and at home with their families. So Will is here today to talk to us exactly about that, and I really appreciate you taking the time, Will. So you can take it away from here. I'm changing the presenter role over to you.
Okay, great. Thank you so much, Pip, for that warm introduction. I am showing my screen, so you should all by now see the first point of my PowerPoint presentation, the first slide. And Pip, one thing I forgot to add in my bio about Disability Rights California, which I think is the most important thing, is that all of the advocacy services we provide to our clients are free. We don't charge anything for our services. We are fortunate to be funded through a combination of state dollars, federal dollars, and through getting attorney's fees in cases like this one. But I'm very pleased to be here today. We are going to talk about getting help with Medi-Cal in-home nursing, and specifically through a settlement of a case that we at DRC have been really investigating since 2016, but filed in 2018, the case on the title INB Kent, around, really based on the state's failure, in our view, to arrange for the Medi-Cal private duty nursing services that children and youth need to live safely at homes with their family. A few goals of the webinar today. We're first going to just briefly go over some common terms that are used in the lawsuit and settlement agreements. I know a lot of this, especially in these systems, can be an acronym soup, and I'm going to try my best to avoid acronyms, but we're going to go over some common definitions and the acronyms of those things as well, so that we're all coming from the same page as we talk about the lawsuit and the settlement agreement. We're going to talk about the parties and the allegations in the lawsuit, review the core components of the settlement agreement, and particularly what's most important, I hope to all of you, is how families will be able to obtain case management assistance to secure Medi-Cal in-home nursing services. And then finally, we're going to review the process for final approval of the settlement agreement, timelines, and next steps. So it's important to kind of note from the beginning that everything we talk about today isn't yet in place by way of the settlement agreement. While a federal judge has preliminarily approved the settlement agreement, it will not be final until class members have a chance to also weigh in, and there will be what we call a final approval hearing in August. And so first, let's just talk about some common terms, which many of you may be aware of. The core of the suit and the plaintiffs in the class, they were all Medi-Cal recipients. Medi-Cal is California's Medicaid program. It is a public health insurance which provides needed healthcare services for low-income individuals, including families with children, seniors, persons with disabilities, and others who meet Medi-Cal eligibility requirements. Medi-Cal is roughly financed equally by the state and federal government, and that's really important for this case because a core principles in our case is when a state accepts federal dollars, it has to follow federal rules, and much of our case was based on federal law. The second term we'll be referring to throughout this webinar is EPSDT services. EPSDT stands for Early and Periodic Screening, Diagnostic, and Treatment Services. It's a benefit of the state's Medi-Cal program. And when we think about early, we think about the state's obligation to assess and identify problems early, starting at birth. Periodic means checking children's health at periodic age-appropriate intervals. The screening component is about providing physical, mental, developmental, dental, hearing, vision, and other screening tests to detect potential problems. The D, diagnostic, is really about performing diagnostic tests to follow up when a risk is identified. And treatment is about controlling, correcting, or reducing identified health problems. And we, in this case, we really focused on the treatment prong of EPSDT because private duty nursing services, otherwise known as in-home nursing services, is that's kind of goes under the T of EPSDT. This case is all about access to private duty nursing. It's known by a few things throughout California. It's known as in-home shift nursing. Some people refer to it as in-home nursing, and it's a service it's a Medi-Cal benefit, the treatment prong, nursing which is provided in a Medi-Cal beneficiary's home by a registered nurse or a licensed vocational nurse, otherwise known as RNs or LVNs, under the direction of a physician to individuals who require more individual and continuous care that's available from a visiting nurse. So that's the treatment. We will be talking a bit about home health agencies and independent nurse providers. Those are the agencies and people that in the Medi-Cal system provide the private duty nursing. So a home health agency is a private organization that's licensed by the state, which recruits, hires, trains health professionals to provide services like private duty nursing in beneficiaries' homes. Home health agencies also typically develop plans of treatment for review and approval by physicians and then provide those services. Here are the private duty nursing or in-home nursing services in accordance with the plans of treatment that are developed. Independent nurse providers, not everyone likes working for an agency. Some people want to work for themselves. Those are independent nurse providers in our system. Still have to be a Medi-Cal enrolled and registered nurse or licensed vocational nurse. And again, it's someone who independently provides private duty nursing services in beneficiaries' homes. A lot of the settlement gets into I'll call it the Medi-Cal service delivery system. In California, I'm not going to get into the reasons why, but it's quite fragmented system about how services are delivered. It can depend on, what county you're in, and there are a lot of kind of nuances that I'm not necessarily going to get into today about like why some people are in one part of the system and why some people are in another part of the system. But the systems we're going to be talking about are all systems covered under the settlement agreement. And the first is what we think of as our traditional Medi-Cal fee-for-service model, which is a traditional method of billing under Medi-Cal for health services where, a healthcare provider, charges separately for each patient encounter or service rendered. So you go to a Medi-Cal doctor, they, authorize a treatment, for that treatment, it's billed straight to DHCS, and, it's a fee for that service that was provided. Another major system within the Medi-Cal service delivery system are managed care plans. And these are healthcare delivery systems that contract with the Medi-Cal program to provide services within a defined network of healthcare providers who are then given the responsibility to manage and provide quality, cost-effective healthcare. Managed care plans typically include HMOs or health maintenance organizations, and unlike fee-for-service where you get paid for the service provided, managed care plans typically receive a prepaid rate, also known as a capitated rate for each member enrolled in the plan. So it's kind of a, come up with a lump sum per member where, in private duty nursing through the fee-for-service system, there is a set rate. That set rate doesn't necessarily exist within the managed care plan system. A few more common terms that we'll be, kind of discussing today as we go over the settlement agreement. California Children's Services, the CCS, or otherwise known as CCS. In California Children's Services, it's a program in California that provides health services in every county to eligible children with certain physical limitations or chronic health conditions or diseases as specified in the CCS regulations. And CCS typically is the authorizing entity of private duty nursing when that nursing is related to a CCS eligible condition. And then lastly, the settlement agreement does impact waiver agencies, and a waiver agency is an agency contracted with the Department of Healthcare Services to provide what we call comprehensive care management services pursuant to the Home and Community-Based Alternatives Waiver. Some people call it the HCBA Waiver, which authorizes home-based services to people at risk for nursing home or other institutional placements. So that was a handful, but these are the common terms that we're going to be discussing throughout this presentation because it really gets to the basics of the lawsuit. And when we get to implementation of the settlement agreement, I'll be using many of those terms over and over again. But I do want to spend some time talking about the lawsuit before we get to the settlement agreement. The full name of the lawsuit is IN versus Jennifer Kent. IN is a pseudonym for the name of our named plaintiff for different reasons like confidentiality and privacy. There are a lot of federal court rules about not putting names of kids in lawsuits. So when we talk about IN, we'll also talk about JB. That refers to the names of the children who are plaintiffs in this lawsuit. We also have the case information, in case any of you are interested in getting more details about the lawsuit. And we filed it about a year ago, May 24th, 2018, although as I'm about to discuss, we filed it after what I'll call a multi-year investigation around the lack of access to private duty nursing services to children and youth who need those services. A little bit about our plaintiffs. IN is our lead plaintiff. I say lead plaintiff because she is the plaintiff that lived within the Northern District of California, kind of I'll call catchment area where we filed the case. And JB was our other plaintiff. We had two plaintiffs in this case. They are both Medi-Cal beneficiaries, and they both had significant medical needs. They both had doctors who signed a plan of treatment saying you need private duty nursing or in-home nursing so that you can live safely at home with your families. For IN, her doctor said she needed 36 hours or 56 hours per week, and JB needed 135 hours a week. And what's important in our system is that their doctors recommend the number of hours through a plan of treatment, but it's the Department of Healthcare Services either on its own or through one of its various service delivery systems, approved the private duty nursing hours, saying that, yes, we agree, these are medically necessary for these children beneficiaries. And that's a really important point that I'll talk about a few slides later, that the Department of Healthcare Services agreed that these services were necessary. So common to IN and JB, maybe common to many of you on this presentation today, they were approved for those private duty nursing or in-home nursing hours, but they rarely received all of their approved hours. It was variable. Some weeks, maybe even some months, they received no hours at all. Maybe a nurse would go on vacation, and there was no kind of plan or person that could fill in, you know, and oftentimes, you know, they both received a fraction of the hours that were determined to be needed as medically necessary. And when our clients asked the state for help, like, please help, we are struggling here, we don't have all the hours for which we've been approved, what can you do? Well, you know, they got outdated referral lists to home health agencies and independent nurse providers. Oftentimes, you know, the same lists over and over and over again. And by outdated, I mean our clients would call up every number on the list, and maybe the home health agency wasn't in business anymore. Maybe they weren't accepting Medi-Cal referrals. So really, sending our clients down I'll call wild goose chase to try to kind of take it upon themselves to secure the nursing that the state itself had determined they needed. Our clients would also kind of get referrals to search engines like Google or Craigslist. One of our clients was just told to just try Google and see what you're able to get. And in the meantime, our clients, their parents, they're really struggling to meet the needs in the absence of the approved nursing hours, the hours that their doctors have said they are needed as medically necessary. So our clients are at risk of unnecessary hospitalization, or also really I'll call it the unfathomable idea that like their children may need to be placed outside the family home, which is really hard for many families that say, well, we'll do it, we'll try to do what it takes to keep our families together, but sometimes people start to reach breaking points. And that was a real problem for our families. We had two defendants in this case, the Department of Healthcare Services. They are the California agency responsible for administering the Medi-Cal program. So under the law, there needs to be kind of what we call a single state agency that's responsible for the entire Medi-Cal program, and for that role falls on the Department of Healthcare Services. So the buck stops with them. That is why they were a defendant in this case. And then Jennifer Kent is currently the Department of Healthcare Services current director. So as the buck stops with her as the director. She is responsible for directing, for organizing and administering the department's programs and contractual arrangements. And that also means ensuring everyone's compliance with state and federal law. And when we think about the federal law in this case, based on kind of what you heard about our clients' stories, we had three primary claims. The first claim was under Medicaid law, and under Medicaid law, there's an obligation under EPSDT. I think we went over that acronym. Although I think I did fail to say when we did this overview that when we think about EPSDT, we think about that as Medi-Cal for children and youth. So it's a program that's only available for children and youth under the age of 21. So this lawsuit is about EPSDT beneficiaries, and under the EPSDT legal framework, there are additional protections where the Medicaid agency, here DHCS, or the Department of Healthcare Services, has a legal obligation to arrange for medically necessary services, including approved private duty nursing services. So a lot of the lawsuit was about what does it mean to arrange for that care? Does it mean to just pay for it? Is it enough to arrange for the care to give outdated referral lists to refer people to Craigslist or Google? In our view, no, that did not meet their obligations to actually arrange for approved services. Another piece of Medicaid law that we relied on was, in Medicaid law, which is the federal law, there are obligations for the state to furnish medical assistance, and that includes private duty nursing with reasonable promptness. So if these children and youth have been approved for services, but there are gaps in services, there are months that they go without, and that doesn't seem like they're receiving those services in a reasonably prompt way once they've been approved. And then the third major claim we leaned into was based on anti-discrimination laws. So we had claims under the Americans with Disabilities Act and Section 504 of the Rehabilitation Act, which gives rise to a state's obligation to ensure that services are provided in the most integrated setting appropriate. So in the absence of services, our clients are at risk of institutionalization. And for a child whose natural state is living at home with their families, and any out-of-home placement really, could be considered to be something in violation of the ADA or Section 504. It's not something that actually has to happen in order to have a valid claim under these anti-discrimination laws, but if their risk is there, there can also be a claim as well. And for children who have been approved for private duty nursing, where that service is medically necessary, where families are really struggling to try to fill that gap in the absence of those services, there's a risk that there's only so long that some families can kind of maintain that situation. So again, based on our claims, the primary allegation in our complaint was that the Department of Healthcare Services and its director, who is Jennifer Kent, they violated federal law by failing to maintain an effective system to arrange for approved private duty nursing services for EPSDT beneficiaries. So again, we're talking about under the age of 21. And by that failure to maintain a system for arranging for approved care, it created a serious risk of institutionalization or out-of-home placement. That was the core of our lawsuit. And we did this as a class action. Well, why did we do this as a class action? Well, we had two, named plaintiffs who are representing the class, and we know through our, I'll call it multi-year investigation, that their stories aren't unique. Before we filed the lawsuit, we spoke with, over 100 families who were also not getting the hours that were approved by the state or the service delivery system, and people are struggling. Same story about getting outdated referral lists, about not knowing who to call, about when they call, an agency that they think is the one with responsibility, they're kind of pointed elsewhere. So really no system in place. And we think that there are hundreds, maybe thousands of children and youth who have been approved for this service but aren't receiving all of their approved hours. And again, really it's as if the burden to arrange for those services, although the state has a legal obligation to do so, shifted that burden to families to, secure the certain nursing services themselves with, virtually no support to navigate what in California is a very complex system. So that's why we did this as a class action. And, we know based on our investigation, based on an access study that the Department of Healthcare Services did in 2016, that there's a huge gap between the number of hours authorized to EPSDT beneficiaries of private duty nursing and the number of hours actually rendered. This is based on 2015 data, but we're looking at over 4 million hours, 4,166,257 aggregate hours across the state that were approved, and how many were rendered? 2,942,347. There's over 1 million missing hours. About, I believe that it's about 30%. So we know this was a problem that, wasn't just about IN and JB not being able to get all their approved hours. We saw that there was a significant problem throughout the state. So without getting into too much about kind of, what led us to the settlement agreement, because once we file cases, there are a lot of twists and turns throughout the case to get us to where kind of we ended up today. I would like to skip and talk about what I think is most important to all of you. Sorry, excuse me. which is to talk about an overview of what's in the settlement agreement. And to do so, I want to start by talking about the settlement class. So because this is a class action, because IN and JV are class representatives, there needs to be a defined class so that we know, and the judge knows, and everyone knows who is getting the benefit of this agreement. So there are three components of the settlement class, and the first component is that the settlement class, it needs to be a Medi-Cal beneficiary. This is about private duty nursing authorized through someone's private insurance. That's not going to be wrapped up within this case or the settlement. The second prong of the settlement class, the class members are EPSDT eligible, which means children and youth under 21. Now, we hear that there are also access problems to private duty nursing for adults. But this particular case was really focused on the Medi-Cal benefits for children and youth under the age of 21. So in order to be part of the class, to get the benefits of the settlement agreement, it has to be a Medi-Cal beneficiary under the age of 21. And the third prong of the settlement class is that the settlement class covers Medi-Cal beneficiaries, who are EPSDT eligible and for whom Medi-Cal private duty nursing services have been approved. So that means that, the class member's doctor has filled out a plan of treatment, and it's gone to, whatever Medi-Cal service delivery system the class member is in, through either a treatment authorization request or other form, but the point is that these services have been approved as medically necessary. So what this case doesn't necessarily cover, or a class member wouldn't be somebody who doesn't currently have or has been approved for EPSDT private duty nursing. So someone, for example, who's in the initial stages, who's working with their doctor, or perhaps a home health agency around getting that initial authorization, but it's not there yet. There may be kind of, some barriers in kind of getting to that approved authorization, but that is not what this case covers. It's just for beneficiaries whose private duty nursing has been approved. And when we look at this class, all Medi-Cal beneficiaries who are EPSDT eligible and for whom Medi-Cal private duty nursing services have been approved, we understand from the department that there are a little over 4,000 children and youth that are in the settlement class. So a significant number of people that this case impacts. So let's talk about what's in the settlement. And I do again want to make the point that everything that we're talking about is not in place today. The court has preliminarily approved the settlement agreement. There will be what we call final approval hearing in August, where class members will have a chance to weigh in about, whether they think the settlement is good, whether they have objections to the settlement. But everything we're talking about, it's not in place today, but through this settlement agreement, we hope will be in place in the near future. And a lot of the settlement leans in on case management obligations, kind of what it means for the state to take a proactive role in arranging for these services. And the way that our Medi-Cal service delivery system works, as we kind of talked about at the very beginning, there are different either contracted programs or agencies that the state uses to kind of run like its Medi-Cal program. So if the court approves the settlement, the Department of Healthcare Services will issue directives or instructions to either county CCS programs, waiver agencies, and managed care plans. And the directives will tell these agencies, hey, you've got an obligation to provide case management services to secure approved private duty nursing for class members in an affirmative way. So not a passive way, but to say, it's on you to make sure that the gaps in hours are filled when someone reaches out to you. No more pointing to another agency, no more giving someone an outdated referral list. The burden is essentially shifting from families, to do it themselves to, the Medi-Cal service delivery system programs and contracted agencies. Now, there may be a family that says, I don't trust anyone else to do it except for me, and that should be fine. But, for a family who's already, under extreme amount of I don't want to use burden, but is doing a lot for their family to keep everything together, they have access to another system to say, hey, it's on you to fill these hours. Excuse me. So under this, the settlement agreement is given a couple of examples of what I'll call required case management activities that managed care plans, California Children's Services, county programs, and waiver agencies will be required to do. One of them is just tracking the number of private duty hours that class members are approved to receive. We've heard from our clients and many other people that like they can't even get a handle when they call, like, how many hours am I approved for? You know, is there a shortfall? I think I should be getting more, but I'm not. So can we all be clear about how many hours I'm actually approved to receive? So tracking the number of hours is kind of a baseline minimum requirement that when families call, you know, either their managed care plan, their CCS, you know, program, or their waiver agency, someone should have that answer. It means contacting either individual nurse providers or home health agencies. Again, these are the agencies that, you know, put the private duty nursing services in place on behalf of class members to come up with a way to staff hours. So again, if the family wants to call, that's fine, but you know, it no longer has to be on an already overstretched parent to kind of make those phone calls and follow up and, you know, try to get the nursing services in place. They have someone that they can lean on now. A third component is that these agencies will also be required to figure out how to work with either individual nurse providers and home health agencies to remove barriers to joint provision of services when necessary. And, you know, by joint provision of services, you know, sometimes there are situations where, you know, a family is authorized for, I'll say, 135 hours per week, and they can fill 100 hours with one agency, and, you know, they found another agency that can do 35 hours, but oftentimes what we hear is that either the agencies, for whatever reason, they don't want to work together, there may be liability concerns, there may be other bureaucratic or administrative barriers to kind of working with more than one home health agency or individual nurse provider at one time. So part of the settlement agreement is that those barriers need to be removed when it's necessary to, you know, staff up a family's case. And the fourth component is that these agencies will also be required to help either individual nurse providers or home health agencies enroll as Medi-Cal providers. You know, we've heard, for example, that the process to become an individual nurse provider is quite burdensome and quite cumbersome. And, you know, many kind of nurses are otherwise qualified and available to kind of fill this gap in our service delivery system. They just drop out. So, you know, through the settlement agreement, we hope that there will be more support, you know, for individual nurse providers to come into the system. There'll be a kind of revisiting of some of the requirements that agencies impose by terms of like paperwork or bureaucracy. You know, we have to still stay within what's legally required, but, you know, the idea is for it to be a much smoother process to bring more nurses and more providers into the system. But those, the four things I just talked about, those are really, you know, what's in the settlement agreement, but how this will be operationalized is that, you know, before the Department of Healthcare Services issues these program directives to managed care plans, to California Children's Services and some waiver agencies, they want to get feedback from the public. And there's going to be a 90-day comment period where all of you, for example, have a chance to provide feedback about these directives. So, you know, and you know, we are, you know, class counsel in this case, so we will also have an opportunity to provide feedback as well. So, you know, there's four kind of big concepts, but, you know, we really want to think through, and especially through this public period, how we operationalize them, how it's very clear, like to these agencies, what it means to arrange for private duty nursing services that have been approved for children and youth in the Medi-Cal system. So, you know, I hope we have another chance to have this same discussion collectively once the public comment period is in place, because we certainly want to see robust and feedback that's given to the state in a way that makes this settlement agreement like work. And another thing important for class members is, you know, once the directives kind of go through the public comment period, once they're finalized, every class member will receive a notice from, one depending on the service delivery system that applies to them from one of those agencies that describes how they can contact, the agency for case management assistance, what it means to provide case management assistance to, arrange for private duty nursing. And there will also be information in those directives around how to obtain information and help from the Department of Healthcare Services, as well as Disability Rights California. It's important for there to be information about how to contact the Department of Healthcare Services, while they make contracts with, managed care plans, or while, CCS or waiver agencies may be part of the Medi-Cal service delivery system. We talked about the very beginning, but the buck stops with DHCS, and overall, it's their responsibility to make sure that things are happening as they're supposed to be happening. There have been questions, from many people we talked to that are part of multiple service delivery systems. Someone may, receive services from California Children's Services, may also be on the home and community-based alternatives waiver and have a waiver agency assigned to them. And then, then we think about kind of CCS and managed care and the relationship between which CCS counties are carved in versus carved out. And for many people, it's like from the very beginning, I need help, but I have no idea who to call. And whenever I call someone, they point to just somebody else, and no one will take responsibility over helping me get my nursing services. So the settlement agreement did try to place some parameters on like, how do we define and how do we tell these various service delivery systems who's in charge? And under the settlement agreement, the managed care plan, again, that's entities that contract with DHCS to provide healthcare services. They're responsible when the class member is in a managed care plan, including a whole child model program where the managed care plan is approved to the private duty nursing services. So it's really then linked to who actually approved the services. California Children's Services, will be responsible for case management when they've approved to the private duty nursing services for treatment of a CCS authorized condition. And waiver agencies, they're going to be responsible when the class member is on the home and community-based alternatives waiver, and neither California Children's Services or the managed care plan has approved the services. So that's the basic framework, and I've made pictures in this PowerPoint presentation. I rely on a lot of text, but even as a lawyer on this case, I'll even say sometimes it makes my head spin to think about how we figure out who's in what service delivery system, to figure out who has the primary responsibility to provide these services. So this picture, even like talking about now, is sometimes how it makes me feel. So another thing that we were able to introduced as part of the settlement agreement is that, the department talks about primary case management as a no wrong door. So regardless of which Medi-Cal program has the primary responsibility to help class members secure their nursing services in the way I just discussed, the class member can still contact any Medi-Cal program that the class member is enrolled in. So if someone's enrolled in both managed care and CCS, or receives services from CCS but is also on the waiver, there's no wrong door. They should be able to contact any one of these programs for which they're enrolled in. And then it's on the entity that the class member contacts to either provide the case management services or work with the other program with primary responsibility to resolve the issue and arrange for the nursing services to put them in place. So this is really intended to get rid of the situation where multiple agencies are just pointing at each other because neither of them think they have the primary responsibility. So here, both agencies have responsibility, and I would say it wouldn't be okay for someone to say, nope, call up CCS or call up managed care. It's on them to call each other to figure out how they're going to work together or independently or whatever it is to secure the nursing services for families in need of assistance. It's really important for us that DHCS, the Department of Healthcare Services, maintained oversight over this whole process because, as we talked about at the very beginning, the buck still stops with them. So as part of the settlement agreement, the Department of Healthcare Services will maintain an email address that class members can contact with questions or concerns about private duty nursing or the case management services they're receiving under the settlement agreement. And when a class member does reach out to DHCS, they have 3 obligations under the agreement. They will forward the message to the appropriate service delivery system or the service delivery system that has been identified as the primary case management entity under the settlement agreement. It's not enough for them to just hit forward on their email and pass the message along. They're going to also respond to the sender of the email to acknowledge, hey, I got your email, it didn't go into a black hole, and then describe any actions that they are taking in response to the inquiry about private duty nursing. But we know that that may not resolve the issue either. So if the class member comes back to DHCS and says, hey, this issue is not resolved, then DHCS has an obligation to take other actions that it deems appropriate to assist the sender to resolve the issue within the discretion of the Department of Healthcare Services. DHCS will also audit managed care plans for compliance with the settlement agreement and has agreed to kind of monitor the service delivery system for compliance with the agreement as well. So those are the kind of, as part of the resource materials that PIP will be including on the Family Voices website, there will be this presentation as well as the settlement agreement itself. I did not go over everything in the settlement agreement. We don't have enough time to do that. So I tried to hit the basics and I think the things that are most important for this audience. But you all have an opportunity to, if you're interested, read about the settlement agreement itself. And it's important that everyone reads it because it is not final. So I'm going to spend a couple of minutes talking about the hearing on final approval of the settlement agreement and next steps. So a few things that the court ordered after it preliminarily approved the settlement agreement. Because this is a class action, the idea is that we are binding members of the class to the settlement agreement. So in order to be able to do that, and we think it's a good settlement agreement, but you need to let people know that it's happening so that if someone wants to say, this is good, this is bad, I object, everyone has the opportunity, or these class members have the opportunity to let the court know. And we do that by giving people class notice. And by June 13th, that is the deadline for the Department of Healthcare Services to mail class notice that has information about the settlement agreement and how to comment on the settlement agreement or object to it. I believe that class notice has gone out to quite a few people because one thing that's in the class notice is our contact information, Disability Rights California, because we are lead counsel in this case. So we've already started to get some calls this week with people asking, hey, I got this notice of class action settlement in the mail. Can you tell me a bit more about it? So for some of you on this call whose children are in the settlement class, you may have gotten this notice already. If you haven't, you should be getting it around the middle of June. And if you are within the settlement class and you never got a notice, please call us so that we can share information about the settlement. We rely on the Department of Healthcare Services to maintain a database of who's in the class and who's not in the class. So it's not always perfect. So we do want to make sure that everyone who's covered under this settlement will get all the information they need about it before final approval. The court has given class members until July 11th, 2019. That is the deadline for everyone to file objections. And then on August 8th, 2019, the court is going to hold a final approval hearing where, we will present to the court, that, hey, judge, everyone's had a chance to weigh in about the settlement. This is what they've said. Some people may have objections that we will want to respond to. And then it will be ultimately up to the judge to decide whether, he thinks that the settlement agreement should take effect or whether he thinks that the parties should keep litigating. And then 31 days following the final approval of the settlement, so the court may do it on August 8th, the court may take the matter under submission. But 31 days after the order, assuming we get one, that is when the settlement agreement takes effect. So that is what then triggers the, the Department of Healthcare Services will have 90 days to put the directives together. They'll have another 90 days to do the public comment period that we all talked about. So there will still be some time before the settlement agreement is fully implemented, even if we get approval on August 8th. And information about the final approval hearing, we have the class notice on our website that we can also give to Pip that she can post as well. But I do want to just spend 2 more minutes talking about resources before we move on to questions. So Disability Rights California, we have a website that's devoted to this case. It has copies of the complaint. It has copies of the settlement agreement, the class notice we just talked about. It also has some significant orders in the case. If you're interested in looking about the history of the case and kind of the path that got us to settlement. So we do maintain a very active and up-to-date settlement website that all of you, I encourage you to visit for more information about the settlement agreement. We have also set up a special number to respond to questions about the settlement agreement. We can take questions from class members. We can take questions from interested parties. You don't necessarily have to be a class member or their family to utilize this line. But if anyone on this call has questions related to the lawsuit, the settlement agreement, questions about access to Medi-Cal, in-home nursing, or private duty nursing for children and youth, that is the 888-852-9241 phone number. I also want to give everyone our main intake line. So for all other issues in which people need help, nursing for adults, or whether it's regional center issues, Medi-Cal issues, special ed issues. So we have an intake line that can triage cases as they come in, and that's the 1-800-776-5746 number. I also wanted to share, the website from the Department of Healthcare Services, and they have a web page devoted to EPSDT skilled nursing services, but it really covers private duty nursing services. I provided a link to that website. And, even though the settlement agreement isn't in effect today, they still do maintain a email address where on their website, they say if you have questions about approved in-home private duty nursing hours, or to report unresolved partial service or no service, which is again, that's what we've really focused on in this case. There is an email address that EPSDT maintains DHCS maintains on their website for how to contact them with questions or concerns. And that is the last slide. That brings me to the end of my presentation, and it looks like we have a few minutes for questions if anyone has some.
Thanks, Will. That's great. Oh, I'm sorry about the echo, everybody. I don't know what's going on there. Well, somebody is asking about, does this settlement, and it doesn't sound like it does, but they're wondering about, does it include in-home support services, IHSS, and RCOC nursing services?
Yeah, it doesn't. So the settlement is just focused on approved private duty nursing services through the Medi-Cal system. So it does not cover any kind of issues that people may be encountering with IHSS or with the Regional Center of Orange County. Although if there are some people that, although they have been approved through the Medi-Cal system for private duty nursing, they have also been approved for, I'll call it nursing respite through the Regional Center system. We view those as 2 different things. The nursing respite is not kind of covered under the settlement agreement. Although if people have questions about their rights to nursing respite that the regional centers authorized, but people are not receiving, I would encourage to call our 800 line 776-5746, and we may have some tips or strategies about how to lean on the regional center to implement the approved nursing respite services through the regional center system.
Okay, thank you. Several people have written in with questions about, for instance, one person, Shirley, is saying that in Fresno, they've got a waiting list for nursing services for LVNs out the 6 months or longer. through the maximum health. They can authorize them, but there just aren't nurses to provide the services. And a lot of people have written in asking about, well, there just aren't the nurses available. I don't know what can be done about that. Do you have any ideas?
Yeah, I guess a few things. So under the settlement agreement, we will certainly kind of monitor it and push on the system to say, hey, it's your obligation to arrange for the services. So there may be a supply side problem that as part of arranging for the nurses to be put in place, you've got to do what it takes to figure out that supply side problem. And one of the things we were able to get in the agreement was to make it easier to bring more nurses into the system through the removal of, I'll call it, bureaucratic barriers that may be in place that is really a disincentive to bringing nurses into the system.
Yeah.
It's hard to talk about this topic without talking about rates. But many of you may know that last year the legislature approved and the governor passed a 50% rate increase for private duty nursing through the kind of fee-for-service system. And I think it takes time for rate adjustments to play out and to see how that bears on market forces. So it's not something that was part of the case, part of the settlement agreement. It all kind of happened at the same time. But what we do hope is that the rate increases along with access to enhanced case management will go hand in hand to try to clear up some of the logjam that people are experiencing around wait lists to getting nurses in place. But for people who have that service approved, where they are told you're still 6 months out, we hope that the settlement agreement will start to move the needle on those issues. And as we get through the monitoring of the settlement agreement, once it's in place, we want to hear about if those issues are still happening in the system, to see if the settlement agreement is doing what it was intended to do.
Okay. Laurie is asking, who has responsibility for private duty nurses for a CCS child that is now enrolled in the whole child model plan? And what if CCS approved the private duty nursing prior to the whole child model launch, the transition into that child's county of residence?
Yeah. So I'd say under the settlement agreement, under the whole child model, if it's the managed care plans that end up approving the services, then it would be the managed care plans who have then the primary responsibility for securing them. But really, whether you call the managed care plan or CCS, it's on those two entities to figure it out amongst themselves, who should be in charge of securing services. I would say for how things currently stand today, I would start by going to the agency that did the approval, where that said, yep, we agree that these nursing services are needed, and start there. But the website that you have up on the screen, which is the DHCS website, which has an email address about questions about private duty nursing services, unresolved partial service or no service, you may also want to try to email DHCS and say, hey, I can't figure it out, or through it in the transition to the whole person model, there's still a lack of clarity around who's in charge. So please help figure this out. And, because ultimately, we would say that the buck stops with DHCS as having the ultimate responsibility for making sure that, approved nursing hours are filled.
Okay. And Will, to your knowledge, is the state developing written guidance regarding the interpretation of medical necessity criteria so that access to private duty nursing services is equitable across counties?
Not to my knowledge.
Okay.
I believe how things used to be done is that the medical necessity determination would be based on how many hours or what the cost would be of an out-of-home placement or an institutional placement, which wasn't a good way of doing business because it won't really look at the child's needs. It would instead look at some arbitrary kind of number and then put a cap on nursing services for people. So the state doesn't operate that way anymore. So it's a much more of a working with the primary care physician and home health agency to come up with what it means to, for those services to be medically necessary. But I'm not aware at this point of any kind of written guidance saying, if you are a child that has like these conditions, or has an event or a trach, and that equals this many number of hours. That doesn't, to my knowledge, that doesn't exist today.
Okay, thank you. Someone's asking about, nurses being paid and how long it takes to be reimbursed. It's saying it's a direct barrier to hire and keep private duty nurses. Are these two issues being addressed in the suit with the department?
Not directly. I think if there is a way, and let me bring up the slide. Give me 1 second. So under the lawsuit and case management activities, on the slide that you all see in front of you, these are the 4 primary things in the settlement agreement that is defined what we think of as case management activities. So tracking the number of private duty nursing hours, contacting home health agencies, trying to figure out how to do joint provision of services, and helping individual nurses, nurse providers, and home health agencies enroll as Medi-Cal providers. It doesn't on point track the kind of reimbursement issue, but going on to the next slide, this is where I think it's particularly important to, when the directives go out and the public has a chance to weigh in on them. Those are the 4 things under the settlement agreement. But that doesn't mean that the state can't do more or consider more ways to, remove bureaucratic barriers that provide as disincentives for like nurses to do their jobs and stay in the system. So I would encourage like all of you on this call, to track this, and we'll also send out kind of informational updates. We can do it through PIP, but about when that public comment period is happening as well, so that people have a chance to weigh in.
Yeah.
And also as part of the final approval process, if there are things that people disagree about, think that the settlement could have done more, think that, and anything that people want to comment about the settlement agreement, that's also another opportunity for, voices to be heard about what the settlement agreement addresses and what, class members may think it leaves unaddressed, and that's fine too.
Okay, we've got a lot of questions. Well, I'm going to run through a couple more, but just want everybody to know that Will has said that I can email your questions that aren't being answered to him after the webinar, and he will do his best to reply. But Will, one more about this is a good question. What responsibility does this settlement give to the home health agency that's providing the nursing hours?
So under the settlement agreement, there's nothing kind of directly that goes to the home health agencies or what their responsibilities are. So whatever mechanism that the state currently has set up around the process for home health agencies and how they recruit, how they train nurses, that's not covered in the settlement agreement. The settlement agreement is primarily focused on, managed care plans, California Children's Services, and waiver agencies. So as part of it, they may then say that we need to kind of change how we interact with home health agencies because it's on us to contact the home health agencies. It's like, do what it takes to get nurses in place. So there may clearly be kind of trickle down to how, how the service delivery system interacts with home health agencies, but there's nothing that's that and it's part of the settlement agreement that goes to home health agencies.
Okay. And there's a couple of questions, Will, about the, in the May revised budget, there's that 50% rate increase is going to sunset at the end of 2021. So can anything be done in the settlement to address that proposed rate? Ensuring that it stays, otherwise it's all kind of null and void, right?
Well, I wouldn't say it's null and void because the settlement agreement leading in on the case management, that exists regardless of what the rate is or will ultimately be. We're at the stage in the settlement agreement where a federal judge has preliminarily approved it, and that's why class notice is going out. So to the extent that people have comments to the court about the rate issue, that's something that people certainly can weigh in on. About how how they feel that the rates are an important, I'll say, component to private duty nursing and the delivery of those systems.
Okay.
But that is why we were in the kind of class notice period and public comments for class members to have a chance to weigh in about the settlement agreement and what else is going on. I can certainly say, taking off my my lead attorney hat for this case and putting on my DRC policy hat for a moment. certainly the sunset of the rates, that's something we don't want to see. And, if those provisions take effect, by the time we get closer to 2021, we will be, vigorously advocating for the rate increase to remain in place.
Okay, that's good. That's good news. I think we need to bring the webinar to a close. Will, thank you so much for educating us all today. And as I said, I'll be sending you the questions that you didn't have time to answer. I'll send them to you in an email. And thanks everybody for joining us. Again, please take some time just to fill out a very short survey to let us know how you found the webinar. And I will be emailing you all with Will's answers that he has for questions. Thanks and goodbye.